Is my microphone on? Yes, it is now. I hope. And the online audience are coming on, and so we can start the conference. We are a few minutes behind, but the good news is that I'm not going to talk for very long at all. Some of you may not know me, some fortunate ones. My name is Renato Nasini. I'm the director of the Center of Construction Law and Dispute Resolution at King's. We are very happy, very honored to host this conference for the 4th consecutive year. The first year was online, and then we went hybrid, and we kept the hybrid model because wonderful to have an audience in person, of course, and there will be, I think there has been already a very good networking, coffee, lunch and drinks this year, sponsored by the London Court of International Arbitration, and we are thankful to them for that. But also we welcome our online audience, hundreds of colleagues, friends, alumni of the Center, construction practitioners from all continents, and we didn't want to lose that, so we keep this model. The Center of Construction Law, as you know, is part of the Dixon School of Law at King's. We do fundamentally 3 things. We run the MSc in Construction Law and Dispute Resolution. It's wonderful to see some of our former students here, some of our current students. And second, we run research projects on all aspects of national, international, UK and international construction law and dispute resolution. Most recently, a project on UK adjudication, for example, and we are going to launch projects on dispute boards in due course, and in the artificial intelligence. And then we host events like this one, which is not just a conference, it's not just, you know, chatting about things that we all more or less know about already, but the idea of this conference has always been to look at the current pressing topics that have occupied us in the past year as construction practitioners, looking forward to the next few years, and having high-powered panels of those people who really have done the job, but also have thought about the issues, discussing, rather than giving kind of dry presentations, but discussing among themselves and with the audience in person and online those issues. And you have seen the program, you all have also a printed version on it. We have a very full agenda, and we really very much look forward to that. Before introducing the first panel, just to say I'm co-chairing this conference with James Pickermans, partner at Jones Day, and visiting fellow at the Center of Construction Law and Dispute Resolution. So James will take over in the second part in the afternoon, and I will instead chair this morning. So that having said, again, welcome to everybody online and in person. And let's move on to the first panel, which is on the use of FIDIC and NEC forms from the point of view of the employer and the contractor in the international market. And I would ask the panelists to take their places. The panel is chaired by Mark Hansen, who is partner in the construction group of Miscondurea and co-head of the commercial construction group. He's a leading construction lawyer with, believe it or not, 30 years experience, ranked as tier 1 in Chambers, member of the Construction Hall of Fame in Legal 500, and he has also covered important roles, including being past chair of the City of London Law Society Construction Committee. I think we agreed to cut biographies short, otherwise, given the caliber of the speakers, we would spend the whole day going through the biographies, but you have all of them in the program. With that, Mark, over to you. Thank you.
Thank you, Renato. Good morning, everyone. Can we just make sure these work? Can everyone hear us? Fantastic, great. So welcome to the first panel session of the day. It's appropriate that we're going first because what we're going to be covering is what happens at the beginning of the project when the parties to a contract go and consider its terms. This is a crucial point in any project, as you know, because experience has shown that selecting the right contract can have a massive impact on the success or otherwise of a project. We're going to focus on two suites of contracts. Firstly, the FIDIC Rainbow Suite from 2017, and then the NEC 4th edition. Now, the FIDIC contracts are, of course, well known, have been used throughout the world for many, many years on many projects worth hundreds of billions of pounds. It's interesting to note that for an organization that was originally founded by the French, the Belgians, and the Swiss, when they came to write their first contract in 1957, they chose an English contract as the basis, and that was the old ICE 4th edition. And even today, you can, if you look at that contract, you can still make out the ancestry of that contract in the FIDIC contracts, both in terms of its approach and structure. Ironically, the descendants of that ICE contract have largely been surpassed in the English market, at least, by the NEC contract, which is now used on nearly all major projects, infrastructure projects in the UK, such as Hinkley Point and Crossrail and others. That NEC contract was also owes its origins. Technology one. That contract also owes its origins to the ICE. And whilst that contract is often perceived as being quite UK-centric, those of us who've been around a long time will remember one of its earliest champions was Eskom of South Africa. And indeed, the contract has been used all over the world, from Peru to Australia, and on all 5 continents, including Antarctica. That said, it's fair to say that in terms of market share, the majority of contracts internationally that we see still tend to be FIDIC contracts, but the market share of NEC is growing. And indeed, when they came to revise the contract for the 4th edition, one of the aims of some of those revisions was to, quote, inspire the use of the contract in new markets. So we have 2 different suites of contract documents, both of whom, despite their common ancestry of the ICE, they differ substantially from each other, particularly in relation to their cultures and structures. And it's vital that employers and contractors, when they're choosing between the contracts, that they fully understand the nuances of both contracts and their differing approaches. So over the next 30 minutes, we're going to explore some of those differences and approaches. And to help us do that, we have an excellent panel of experts. On my left, we have Nicholas Gould. He's a partner in Fenwick Elliott, a solicitor and a chartered surveyor. He has extensive international arbitration experience and is, of course, the past chair of the Society of Construction Law. On my right, I have Gillian Thomas, partner at Hogan Lovells. Gillian's practice focuses on the procurement of complex construction projects, both internationally and domestically. And Gillian's a past chair of the City of London Law Society Construction Committee, a very august body. And finally, by no means least, we have Shai Jackson. And Shai is partner at Brian Cave Leighton Paisner. His practice focuses on complex dispute resolution. Shai is a visiting fellow at King's, and very pertinently for today's discussion is also a member of the NEC board. So we've got a limited amount of time and a lot of ground to cover. I'm sure there will be questions, but let's leave those to the end. There will be roving microphones, I think, for people in the room, and those online can use the chat function to ask questions.
Please.
The what function?
Q&A.
Oh, Q&A function, sorry. Technological ignorance showing there. So let's start off with I think what we'd say is the main difference between these 2 suites of contracts, which is the differences in culture and therefore the behaviours that are driven by the differences in culture. So Nicholas, they really are quite different in approach, aren't they?
Yes, I think so. Yeah, I think you're certainly right. It was interesting to think about the history of NEC and FIDIC, because it looked like quite different contracts today. But going back historically, it was the ICE, wasn't it, that, as you said, that produced the old ICE forms. I think that one thing, though, is certainly very true when it comes to picking a standard form. The industry doesn't really. The industry sticks with familiarity. And so that's what we have. We have the old ICE form that was used here, and then it got transported around the world by the engineers. It's been used around the world a long time ago, which is why the FIDIC picked it up. It was the only standard form really to pick up. It made sense just to put a choice of law clause in it, and away you went. We see the NEC now being, the lead contract for the ICE. It's new approach for some time, since 93, 94. But still, I think contract forms are picked on the basis of familiarity. So, the tendency would be to think that you select a procurement method and then you pick the right standard form to go with it, which is what you should do. We spend our lives telling people to do this and suggesting that they do that. But in reality, what happens is a standard form has been used by the lead consultant that is involved in the projects for those particular clients or governments, and they've used a standard form for years and years and years. And if you go to a particular country for infrastructure, it probably was the old FIDIC. And we mentioned 2017 now. Well, I bet most places around the world are still using the 1999 with some amendments, because that's what their engineers have been using. They're comfortable with it. They may have made the switch from red to yellow, so from traditional to design and build, and then maybe silver, or they've stolen some clauses from silver and put them into yellow to make it look like it's still a design and build contract with a bit more risk hidden away. And that's really the culture of the world over. I mean, I work in many different countries, and that's what I see. So what I suppose I'd like to say then about culture and behavioral mindset is that you pick the form that you think you're familiar with, because you learnt about it at college 30 years ago. I hesitate whether some people have read it since and realize it's been amended and been up. I sit with people that tell me how the payment system works. I'm thinking, that's the 1987 FIDIC, isn't it? So that, people pick, I think, their form because of that. So just to conclude on that, I think the difficulty is that it's quite hard to get change. It's quite hard to see the NEC.
But we do see clients in certain countries and jurisdictions specifically choosing to move away from that mindset and embracing the NEC and the different approach of the NEC. I mean, Shai, do you want to say something about that?
Yes, and it's probably best by starting with what Nicholas has covered, which is really this traditional approach where we do what we've done because we've always done it this way. And I think lawyers are certainly guilty of that as much as the industry. That's our drafting. We love precedents. That's the background to how we use contracts, and that's important. Very conservative environment, resistant to change. The other thing that we have in construction, which is also very traditional, is this adversarial position where we start a project expecting, almost hoping for a big final account dispute. We'll start with certain assumptions, lack of trust, focus on delivery, work on the claims. And that's how people have been doing it for hundreds of years. And it's worked very well, especially for the lawyers. But NEC, in terms of culture, is an attempt to move away from all those things. And it is a challenge. It's a challenge in the UK, internationally even more so. But as Mark said, it's been very popular in South Africa. It's growing up in Peru. Hong Kong, in July, they've released a special version of NEC for Hong Kong, which incorporates the local requirements. So it is growing in use internationally. And I think when you look at the international context, you need to think, how is it different from what we're used to? Drafting is a key point. The traditional approach to drafting by us lawyers is cover every possible eventuality. The only small problem is that you end up with very long contracts. And if you look at the 2017 FIDIC, it is quite a heavy document. NEC tries to keep it short, simple English. Not everybody likes it, but in international contexts where you've got people whose first language is not English, like myself, it should be easier. Doesn't always work. It assumes you understand the principles, but that is a big fundamental difference. The other thing is this idea of collaboration, spirit of mutual trust and cooperation, or what we lawyers call good faith. Now, internationally, that's not a problem. If you come from a civil law jurisdiction that's accepted, even other common law jurisdictions like Canada and the US are used to it. And English lawyers really struggle with agreeing to behave in good faith. I never quite understand why, but it is a big cultural difference. The idea that you enter into a contract and commit to that, I think in a way, internationally, it's a lot easier to do than it is in the UK. The other thing, and that goes back to origin, because ultimately I see, is this idea of proactive project management. And like I said, traditional approach is we leave it all to the end, we deal with problems as they arise, and we argue about consequences. NEC sells itself as not just a contract, it's about project management, proactive discussions, early warnings, using the program. And that is a very different approach. It's a different way to use contracts. It doesn't just tell you who's responsible when it goes wrong. It tries to help projects get delivered better. And the other thing is, which is part of that, is not leaving it all to the end. I fully understand why people like to postpone problems and say, we'll deal with that at the end. We'll focus on delivery. But by then, nobody remembers what happened. It's a bit more difficult. The big difference in NEC, it says we will deal with it as it happens, look at it prospectively, and that will be the end of it. Until NEC 4, there was no final account process, which is a really big cultural change. So this is how NEC is different. As Mark said, there's a lot more interest internationally because people have been doing things in the old ways. I'm not sure it quite works. When they're looking for a different way to deliver projects a bit more efficiently, they're interested in understanding how NEC works. And I understand if we keep on doing things in the same way, we'll get the same results in a way it works. But I think it's worth trying new things.
I mean, thanks, Si. I mean, there were some very pertinent points there. And I think what we're seeing in the latest versions of FIDIC is an appreciation of the benefits of that sort of proactive approach in contract management. And the latest versions of FIDIC now have started to move towards similar ideas around programming and proactive management of contracts. So clearly it's something that the market would like, and we are seeing a bit of a convergence there, which I think is quite interesting.
Yes, and all contracts learn from each other. And like I said, NEC recognized that the final account process to an extent is also suitable. But it's difficult to argue with good principles of project management.
I mean, one of the areas that the contracts do differ structurally, I guess, is in relation to payment, isn't it? So, Gillian, do you want to just talk something along the lines of that?
Yes, thank you. So looking at the different approaches that are adopted here, all of the FIDIC contracts adopt a fixed lump sum approach to pricing and then interim payment. The NEC contracts with their modular format offer a wider range of pricing approaches. So they cover the fixed lump sum approach, the cost plus approach, and the target costing. And I think I think that as we have our forms, and then we have real life as well. And I feel that real life is sort of developing in a way which the forms, perhaps, well, the NEC is more akin to where we're getting to in terms of market position than the FIDIC one. The fixed lump sum approach, which FIDIC gives us, is sort of very attractive for employers initially, because obviously it's placing a huge amount of risk with the contractor. He is pricing for all of the unknowns, the unknown unknowns. And, you know, in recent years, we've seen COVID, we've seen the war, contractors becoming very focused on all of these unknown risks that they are pricing in with their fixed lump sums. Both of these contracts are aimed at the very large, complex projects. And I think for those types of projects, there's increasingly a limited pool of contractors that are available that can actually deliver on them. All of those contractors are looking at a more construction management, even if that's not what the contract is saying, a construction management approach to their business, where they're looking at a cost plus fee type recovery. And that's what their business model runs off. So I think that the NEC has got a much better approach in terms of the realities of where pricing is getting to for the larger and projects which always carry with them so much uncertainty.
So
Um,
are these things then cyclical? Because when we have seen, casting my mind back over 20 years, is these surges in popularity of NEC contracts on a target basis when the market has been very tight, contractors have not been willing to take risks. And to some extent, that has fallen away when the market has become harder and or projects have had budget issues when let on that basis. So certainly I've seen these waves of popularity of the NEC and the way it prices jobs coming and going, differently over decades.
You're completely right on that. I have to feel that, contractors do seem to be becoming a lot more sophisticated in understanding exactly what the risk is that they're accepting here. And having got this far, I think it's quite difficult to see them going back to an approach where they say, don't worry, competitive tender, we really want the work, we're just going to put a fixed lump sum price to it, especially when you're looking at the really, really complex projects, the offshore wind farms, the tunneling, the airports, all of them, I think, are moving more towards the target cost pricing, the alliancing models, and so moving away from that fixed lump sum.
Is that your experience, Shine?
Yes, I mean, as Gillian said, the traditional model of fixed prices means either the contractor prices for lots of risk and it may not be value for money, or they end up underpricing and then the focus is on claims and recovering margins. And for large complex projects, I think experience tells us that it's not quite the right way. NEC has 6 payment options, and in a way that forces parties to think about how they want to structure the commercial bargain, because they have to choose one of those options. It does mean they need to understand how those options work and how they allocate risk. But if they understand that, then they can make a conscious decision as to how to model the commercial bargain. And there's been this mention of target cost contracts. We're quite familiar with them now in the UK, but when you speak to people internationally, that is the thing that people find more difficult to understand and sometimes struggle with, because it is a very different concept. And for those who are less familiar, in very simple terms, when you start the job, you don't agree the price, you agree a target, hopefully a realistic one, based on what the cost is expected to happen. And then as the works progress, 2 things happen. The target will get adjusted for employer's risk, change, ground condition, etc. At the same time, the contractor is paid the actual costs, subject to very few exceptions, and a bit of a profit and margin. And at the end of the job, you compare the cost to the target. And if the actual cost is below the target, everybody shares the savings and the contractor gets a bit extra. If the costs are above the target, everybody shares the overspend and the contractor has to pay back a bit. It's a fairly simple model. And you can see that the incentive is, it's in everybody's interest to ensure that you come below the target, not above it. In practice, it gives rise to challenges. Employers have to understand that sharing the gains means sharing the pain. They have to understand they'll be taking part of what are traditionally contractors' risks, such as fixing defects. But again, it's part of the ethos of, for a very big complex project of a large number of years, parties have to collaborate. We recognize they have to be forced to collaborate sometimes, and a target cost is one way of doing it. There's also a larger use of incentives, KPIs, and these are all ways of using the payment structure, because it is all about the money, to encourage more collaboration and a move from the environment where parties think, well, it's your risk, I don't really care, into it's our risk, what's best for the project. If we work together, everybody will benefit.
Yeah, I think it's a good point, Shai. I mean, just to come back on one of those points, one thing I found very hard to explain to clients on a target cost contract basis is that they have to pick up some of the cost of the contractor rectifying his own defects if there's an over and over the target. That's very hard to explain to clients, especially outside the UK. I was just wondering also, have you ever had a target cost contract where the cost has come in below the target, which has been a large project? Because I never have. I don't know if anyone else has.
It does happen. I think the difficulty is, like all those things, understanding what the model requires. And a target has to be realistic. And if you use the traditional procurement methods for a target by finding the cost and then pushing everyone to come in with a cost that everybody knows is not realistic, then on the first day, instead of focusing on savings, all the good stuff, you can see you're starting automatic pain and you're going back to the old culture of claims. So I agree with you. You do see a lot of cases where it's above the target, but I think if people think about it, you need to understand the target has to be a realistic one.
Okay, well, let's quickly look at some of the sort of key risks in the contracts and how they're dealt with differently under both approaches. So, Nick, should we just start with ground risk and how the two contracts differ in the way they treat that?
Sure. Okay. Thank you. Yes, I suppose if you have a look at the FIDIC Red Book, ground conditions, physical conditions are dealt with in clause 412. I always thought that was rather strange because if any of you remember the old ICE contract, it was clause 12 out of the 67 clauses, and now it's 4.12, despite all the reorganizations, this strange synchronicity between the two, but there we are. So physical conditions is basically, all those conditions you might encounter on the site, but it's fairly subjective, isn't it? And if you go to the NEC, in relation to weather, you see something that's quite objective, but when you go to ground conditions, it's the discovery of physical conditions which an experienced contractor would have judged had such a small chance of occurring, slightly different test. So you can see how the drafting committees are trying to pick up a different way of dealing with the same problem, but I still think coming to the same kind of problem anyway, because it's subjective. When a contractor prices something, they've got a small amount of site data, and when there is an occurrence of what they believe to be different conditions, the other party is bound to say no. And there's a sliding scale, isn't there, of difficulty. You always end up having disputes with these things. It can't really be avoided. You can try GBRs, geotechnical baseline reports, to try and set out a matrix of something a bit more objective, but you've still got this question of, well, is it really different? Does it fall within or without the matrix? And what was the size of your sample? And how much did it affect? So I just think it's one of those areas, no matter how you try to draft it, it's very difficult to cover. You could go silver book and just deem all ground conditions that are the contractor's fault. Often a bit of a shock for the contractor when they've signed that up. I don't know if you can read it. I'm sure some of them do, and try to negotiate it out. Maybe it's just the ones I see that haven't. But it is quite a risk to take. And as you were saying earlier about the move towards different approaches to contracting, it is because contractors just won't take those risks, and it is more sensible for the owners to take some risk back and get a better price, isn't it?
I was going to say on the front end as well, my experience is, we get a set of terms and conditions put in front of us, and the first tentative clarification that comes up or exclusion is we're not accepting that on, if you're building an offshore wind farm and you're trying to put, lay the cables for it, how on earth can you accept that risk? You just don't know what's there. And as you say, there's only so many contractors that can do the work, and they're not prepared to sell the farm for the cost risk that involved in that.
Should we just move on and have a quick look at design risk and how the two contracts differ?
Yeah, I was going to say, I think that, this risk and the pricing really, fit together. And so, there is an impact on, what risks people are prepared to take depending on the price. I think you wanted me to talk a bit about the design and the approach again with the FIDIC, between FIDIC and NEC is very different. The NEC, of course, it has the options, the option dealing with design, and that requires reasonable skill and care. The FIDIC contracts, depending on which one you're looking at, if provided it is one that has got design in, you can be looking at fitness for purpose. We've had quite a lot of recent case law where contractors are beginning to understand quite the scope of the design responsibility that they're taking, Hogard and the SSE Hochtief cases, and recognizing that they can't get insurance for that sort of liability. It is again an enormous risk that they're taking, and if they have gone for lump sum pricing, they're bearing a huge amount of the cost consequences of that risk allocation.
The NEC itself isn't entirely clear on fitness for purpose either, though, is it? So there is a risk if you're using that, even if you're using the optional clause, which tries to limit things to skill and care, that the contract documents contain things which require fitness for purpose, you might be caught too.
Yeah, I think that's one of the issues that comes out of the NEC being, in its brevity, it has, a lot of attraction, but again, sometimes you just need some more words around it. And for design, I just think that's one of these areas. So there is a reference to works information that, design responsibility is captured there. That documentation isn't the stuff that the lawyers tend to look at. And so there is the risk that you have differences in approach in what the words say in the conditions and then what the words say in the works information.
So is it actually one area the much maligned JCT actually is clearer on, I think.
Yes.
Great, that's very helpful, thank you. So let's move on now to one of the sort of signature issues in the NEC and of an issue of increasing importance in FIDIC, which is the role of the programme, the contractor's programme. Shai, do you want to say something about that first in regards to the NEC and then in regards to FIDIC?
Yes, I mean, everybody should accept a good program is crucial for good delivery, shouldn't be an argument. What happens in practice, I find, is that you will start a project with a good program, but how things develop is what makes a difference. And contractors will have their own programs, clients will have their own, the managers. And especially when looking at entitlement, it creates all those difficulties, and NEC tries to avoid it. And I guess the two big differences. First of all, it's quite prescriptive on what the program has to include. So you put in things like float, time risk allowances, and periods for complying with contractual processes, but also it's not just about the contractor, it's about everybody else. So it includes everything the client has to deliver as well as third parties. And that's really useful because everybody has an understanding on the role. And the client, for example, will understand that if they don't do something, they can see it's on the critical path, and it's then more difficult to argue as to the impact it has. And then the other big difference is that there is a mechanism for updating it and agreeing it on a regular basis. And the idea is that every month, usually, you update it based on progress, what's happened. It goes to the project manager, who either agrees or explains why it does not agree, and then the contractor can either fix it. But at least there is a good updated program that can be used to, first of all, manage the project, incredibly important, but also assess entitlement. So all great in theory. I think in practice, we know it's not quite so easy. But that's an issue in my experience that doesn't just apply to NEC. It's also other forms of contract at the initial level, because first of all, you have to invest in resources, don't you? You need to have enough planners who know what they're doing, especially on large complex programs. The other thing is that the project manager or the engineer has to engage in the process. And there's always the risk of people trying not to make decisions, not to respond. They're cautious that if they agree a program, it means they agree an extension of time. And that sort of defeats the purpose. NEC 4 has a deeming provision that if the project manager does not respond, it's deemed accepted, and trying to force people to get to it. Because the simple point is it requires a lot more effort, but if you do it, there are great benefits, both for project delivery. It's easy to manage a job, easy to assess assessment, but also if you do end up in dispute, there's a few delay analysts, I think, in the room. There's a lot less need for the work they do, or at least it becomes a lot simpler because you have a program that's been updated contemporaneously. It represents their as-built position. It makes life easier at the end of the day.
Thank you.
Yeah, yes, and I think it's good to see that these standard forms have included a longer shopping list of things you require in a program, FIDIC and NEC, and it's great to sort of see what you might need in there, particularly lead-in periods, procurement periods, where the design phases and approvals, but rarely do we see that in programs, do we? We kind of see strip the site and away you go. These things are often forgotten, despite the fact the standard forms changed and we need these things built in. So it's weird to see the industry still has carried on in the way it used to before it was a design and build industry. But as Shai said, there's a lot to do, isn't there, up front? And I'm not sure why standard forms don't adopt a process of an initial basic overall program and then a short 3 or 4 month look ahead at the start, because they could do that much more easily. And in reality, that's what contractors try to do. The other thing, of course, about updates is that they often are not agreed. And this is because there's a little bit of a game going on. I've got a project at the moment. It was 4 years long. It's going to be 5.5, 2 years in. They're about a year late. And the first program was accepted. The second ones have not been. And to be totally candid, even though they're not saying this to each other, really what's happening is the contractor's a little bit reluctant to show everything that's going on, because some of it's their fault and some of it might be the employer. So it's best to kind of make it look like it's all the employers. The engineer knows this, but can't quite fathom out what's happening, so it's rejecting the programs. This means the job's going to go right the way through to the end without an agreed program, and it'll just finish when it finishes. And retrospectively, when we've all forgotten what happened, there'll be a big argument about what really caused what. So I like the NEC's approach to go and look now and make a decision. And I think that's good for those projects where that happens. And the challenge is still there. It's not really what's in the contract, it's about how you run the job, I think.
Yeah, and I agree. I think it's absolutely crucial. So you can write as much as you like into the NEC, which makes it a proactive tool for managing the job. But if those who are administering the contract, those who are working under it, don't fully understand what is required of them, and aren't familiar with the contract, then that very quickly breaks down and actually can put you in a quite a difficult position if you're either the employer or the contractor. So it goes back to this the cultural approach of the NEC. If you're going to use it, really have to know how it works and be properly up to speed on it. It is not at all like the FIDIC forms or indeed any other ICE engineering contract. Okay, staying on the sort of cultural differences theme, one of the areas that I think it's probably worth drawing a bit more out on is change control and how it differs under both contracts. Gillian, do you want to say a bit more?
Of course, the FIDIC contracts are adopting the traditional approach that we're used to of, permitting the employer to instruct, change whenever they like, and subsequent valuation. NEC approach very different. As all changes are treated as compensation events, and so there's a prospective assessment both of the cost and the programme impact that needs to happen when the instruction is made. Now, both of those approaches seems to be are perfectly fine, provided the parties are complying with the procedures that have been set up in the contract. Problem arises where contract administration is not observed, and then the valuation is not happening consistent with what the contract is expecting. FIDIC, like you said, we end up with a final accounting process, but as change has not been sort of valued and looked at the time that the change was instructed, then disputes can arise as to, what happened, what was actually impacting on the delay, or what impacts were causing the delay. With the NEC, contract assumes the prospective valuation, with no mechanism for assessment really where that's not observed. And while we have the benefits of, Shai, you've mentioned that, the NEC4 has now introduced this sort of final assessment stage for payment, which could be equivalent to the final account. It provides a structure, but it doesn't deal with this issue of retrospective rather than prospective assessment of change. And that, certainly on the projects that I've worked on, is where the difficulty comes about. You're looking at change in the context where you might not have an accepted program, and people can't implement the contract terms, and let alone any core adjudicator or third party expert that's drawn in to try and create a determination.
Sure.
Yeah, I'll keep it short. It's a very simple choice, and for the parties. Are you happy to commit to agreeing change as it happens, and that will be the final answer, and you don't have to worry about it later because that's what you've agreed? And in a way, it gives the client certainty, and it gives the contractors sometimes a target, because if they come below it, there are benefits to everyone. Or do you prefer the traditional way that we'll try to agree the value, but we all know that we'll have an argument about it at the end, and then it will be what it will be based on actual cost perhaps, but on a very long project, it will be a while before you know what's the real value of this change.
Indeed, that's a very well put. Okay, I think we have exactly finished on time, but as we were 5 minutes late in starting, we do 5 minutes of questions. Great. Any questions in the room at all?
There's a mic.
There's a mic coming, don't worry.
Thank you. Good morning. I'm Stephanie Bonini. I'm a civil engineer and a lawyer from Panama City, Panama. And I bring a question about the contract NCE. I was thinking, since I come from a developing country, you know, the biggest client that we have right now is the government. He's the one that usually do big projects. So how do you think we can convince the government to take on this new form of contract when we are so used to FIDIC? Thank you.
I think it goes back to your point, doesn't it, Nicholas, that it's the familiarity of the technical advisors that are going to be involved early doors on the project. And I mean, certainly when it was introduced, the NEC contract had an amazing publicity department. I seem to recall that everybody was talking about it. I don't know if they need to get that going again.
Well, it needs it a bit less because it's being used more in practice. So in Peru is a good example because again, people sort of assume it, they say, okay, Hong Kong, Australia, South Africa, it's understandable, common law jurisdictions. But the fact that it's been adopted in Peru so much, and it's a bit of a history of the Pan American Games, there was a UK involvement, but they've started using it and they like it. And the government there is using it on more projects. So it's looking at experience and it's talking, understanding the benefits and trying to understand, is it a different way? Are we happy with how things are going, the traditional way, or do we want to try something else? But you have to do it slowly. I wouldn't recommend jumping straight into NEC from something else without any understanding, training, support, workshops, all the usual stuff. But if you're willing to invest a bit of time and understand, things like program early warnings, other contracts are using that as well. There's no reason not to.
Yeah, and it is used in other civil jurisdictions, isn't it? It's been used in Belgium and
Yes.
Holland, and so it's not just a common law contract. You can use it elsewhere. Yeah.
Can you wait for the microphone?
It's the question for Shay, because you mentioned that NEC is more like a shorter culture version that based on the good faith as well. And I was just wondering why you mentioned it's more much easier in the international projects rather than I guess you compare it with the UK one. Just wondering why is that case?
That is a very good question. I guess international experience sometimes, and maybe that's just my experience, the English law approach is very strict letter approach. Conditions precedent, time bars. If you're one day late, you're out. I think what you see in other jurisdictions, say the Middle East, there is sometimes a bit more expenses. The expectation that where the civil law system has good faith provisions, that's a way sometimes for the tribunals to work around a very strict application. And I do see it a bit as an English law approach, it's very much all about the contract, black letter. You live and die by what you signed up to, while in other jurisdictions a bit more, yes, but we also look at fairness, good faith, other principles, the overall context. And that's why I think that there's a bit of a difference in approach. So it's probably a topic for another conference or panel.
Yes.
Well, that's why NEC in a funny way, and I find that it's much more welcomed by the construction industry than by perhaps the legal industry, if I can put it this way.
And by funders.
Yes, people who don't quite. You need to understand the benefits and why on very big complex projects, taking this kind of approach has possible advantages against a very strict application of contractual provisions.
Yeah, I mean, if you think it's hard explaining target cost contracts to clients, you should try explaining it to a funder.
Yeah, especially on a PFI project.
Yeah. I think we have time for one more question.
One was that? If you could be quite succinct.
Just picking up on the point that you made that you've never seen a target cost contract come in gain share. I've just finished on one, but it came from a 4-year early contractor involvement period for a 3.5-year construction phase. So do you think there will ever be a maturity shift where there's more clients that understand that if you invest up front in training your staff and the design phase and taking on a bit more design risk.
No. Oh,
Then-
sorry. It just came out, so.
Well, you know, as someone who does a lot of work for clients, I think you'll find that they are. So certainly most of the clients I work for now will always have an early contractor involvement phase of varying lengths, and do take quite seriously that period of time to enable them to get to a position where everyone knows what it is they're supposed to be building and for how much.
The
So-
construction playbook, I mean, that's
Yeah.
trying to embed exactly that point.
Correct, yeah, and that applies as private and public sector.
And part of it is for me, I think, a sort of a respect that the contractor has got a lot to offer. Because I think for quite a long time, public sort of bodies have always thought that they knew better, and the contractor was just to get on with it and would bring claims and be difficult. But there's a realization that when it comes to actually turning the idea into physical reality, requires a whole and they can add a lot, and it's just accepting that, isn't it? Bringing them in and working with them, and the sort of suspicion of what both sides are up to evaporates, and then it works really well.
Yeah, then the second part of it is the contractor then the maturity to understand that any change that goes on throughout, they may not recover all of the value or time that they need for it. But if you're both working together because you've set it up correctly in the first place, then you should finish on time, which this project has. I've never worked on any others that have, but one.
Well done.
Okay.
Well, 4 years of early contractor involvement,
Yeah.
I'd hope it would be below the time.
I mean, if after 4 years of early contractor involvement, I mean, the project had been a disaster, that would have been really, really problematic. But I think one of the issues for indeed funders and some clients, etc., is indeed this long period of early contractor involvement, that it's a big investment and it's clearly sometimes not understood. I agree, and becomes a concern or a worry, at least in my experience outside the UK. It's not always a very easy model to sell. Is look, 4 years early contractor involvement for a kind of 3-year project or things like that. Training and understanding is key. Now, we do need to bring this to a close. So thank you very much, Mark, Nicholas, Shai, and Gillian. Let's thank the speakers. Thank you very much.